Good afternoon, everyone. Aaron Keller along with you for the afternoon hours, as always, here at the Law and Crime Network. We're listening to the so-called Cloud 9 trial out of Florida. 3 defendants facing second-degree murder and attempted second-degree murder charges related to the death of 1 person and the injury of 5 others. Now, the most severely injured of the 5 who were hurt in this shooting is Nathaniel Kendrick. He's the witness on the stand right now, and we've been requested not to show you his face. This is an important witness because he's one of the few witnesses who has pointed the finger at all 3 defendants. We've heard that Laquan Barrow was involved from almost every single witness who's been up on the stand. But this is where we're starting to see the implication of the others, specifically one of the others who the other witnesses just didn't really see at all. So that's really critical for the state, because before today we had next to nothing implicating defendant King in this shooting. The state just doesn't have as many witnesses pointing the finger at him, especially after one of the witnesses refused to testify yesterday. The back and forth here is that this witness previously had not implicated all 3 defendants in previous depositions and previous statements. So the defense is trying to pick apart what he's saying on the stand. Let's go back to court.
Mr. Bankowitz asked you a question, and as to whether the individuals were there or not, and if you identified them, and you said you didn't remember, and he said, well, I can show you something that will help your memory, and you told him that it's not going to help my memory, correct?
I said refresh my memory, show me and refresh my memory.
Right, but you told him that it would not refresh your memory for him to show that to you.
He's answered the question.
Okay. Yet when the state attorney approached you and asked you the exact same question as to whether or not looking at it would help you refresh your memory, you said that it would, correct?
I say refresh my memory, show me.
Okay, to the state, and you allow the state to show it to you.
If the lawyer would have showed me and refreshed my memory, I could have given the same answer, but he never showed me.
You recall him having it in his hand, walking towards you?
I say refresh my memory.
It's sustained.
Mr. Kendrick, you have been convicted of 6 felonies, correct?
Yes, sir.
Thank you.
Ms. Hawthorne.
Mr. Kendrick, I just have a few more questions for you. How tall are you, sir?
6'1".
How much do you weigh?
Right now, probably about 250, 255, something.
And were you about the same weight back in September 2015?
Yes, ma'am.
On Were you on probation
Yes,
at the
ma'am.
time of this incident?
Sustained.
Were you using any illegal?
Can we approach, Your Honor?
Yes.
The attorneys and the judge and the court stenographer once again having a sidebar here. We're in the midst of a re-cross-examination of victim Nathaniel Kendrick. He was the most severely injured of those who were injured outside the Cloud 9 nightclub in Florida. 1 died, 5 were injured. This particular witness was shot in the chest. Now, on this second go-round, we just saw one of the defense attorneys say, hey, wait a minute, why did you allow the state to refresh your memory with prior documents, but not allow the defense to refresh your memory with previous documents. What we're trying to get at here is whether or not this witness is biased in favor of the state, because this witness on the stand implicated all three defendants. In prior statements, he only implicated one of the defendants. The defense attorneys are trying to straighten that out. Let's listen back in.
Let me know when you're ready. Okay. Do you remember telling us at your deposition that being shot has affected your life every day?
Yes, ma'am.
And that mentally you're not really there?
Yes, ma'am.
Okay. Thank you, sir.
Is the witness excused?
Yes, sir.
All right, Mr. Kendrick, you can go about your business.
The young lady as well.
Ladies and gentlemen, we're a little past the point I would have preferred for your break, but we'll take it now. Again, hold your pads, leave them on your chairs. It'll be approximately 15, maybe as much as 20 minutes.
In the hospital.
You're watching the Law and Crime Network. The judge has just called a break in the case we're watching. This is the Cloud9 murder trial. One person was shot and killed outside of a club. It looks like the judge might be taking up some issues outside the presence of the jury. I want to listen in just to make sure I don't miss anything. It sounded an awful lot like the judge was going to start addressing the attorneys there. He said, well, we're outside the presence of the jury, and then nothing happened. So let's go back and talk about what's happened this afternoon. David Schwartz is with us here on the Law and Crime Network. David, good to see you.
Great to be here.
So we've got three defendants on trial, right, and we've got a state's case that yesterday was floundering seriously, right, because one witness basically refused to tell the truth on the witness stand. He got held in contempt, right, and another witness recanted an identification. So that left the state in a bind because the state didn't have one of the witnesses that was going to point the finger at one of the defendants. Well, now we have the flip happening. We have one of the victims, who was the most severely injured among the five who survived, who initially only pointed the finger at one, if I'm remembering this properly, one of the defendants. Now he's saying all three were involved. So what's going on here?
Well, I mean, this is why we go to trial sometimes as defense attorneys, because many times, especially in a case like this, the case falls apart. It sometimes will fall apart right in the middle of the case. Prosecutor, and I'm a former prosecutor also, so you prepare the case, you do the best job you can, and the witness still has to take the stand, and they still have to play out the contest, right? It's almost like
exactly.
like a basketball, you got to play the game. And many times the defense banks on the fact that, especially in this type of case, gang members, where the case will just fall apart. And that's what's happened to the prosecution right now, in fact, with all three witnesses, because you have this witness on the stand who originally only identified one defendant, and now all of a sudden he's identified all three. His credibility is in question.
So yes, his credibility is in question, but is the jury going to buy his explanation for it? And his explanation was, I'll never forget the face of someone who's trying to kill me. That was a comeback to a question asked by one of the defense attorneys, who I think has been handling the case very, very well. But that's the sort of thing that sticks in the jury's mind.
Yeah, absolutely. There's a very powerful moment in the trial. We both leaped up when we heard that, because even though this witness has credibility issues, he has 6 felony convictions. He could remember certain things at one time. Now he remembers other things, and his testimony now is much further in time from when he gave the depositions and when he gave all the police statements. But that was a powerful moment, and I think it was a real moment for the jury where he said, I could never forget a face. It sounded very natural. So, even if a witness does have credibility problems, the jury could either not accept any of his testimony, or they're allowed to accept bits and pieces. And that's a piece of testimony which, at least from this standpoint, felt strong.
It did from my perspective as well. And maybe it's believable that this guy, you know, initially after the shooting, he was in a coma for a month and a half.
Right.
And he's saying, hey, look, you know, they came to talk to me as soon as I was coming out of it. I could clearly identify one guy. I mean, as memories tend to happen, they do tend to come back in situations like that. If he's laying in the hospital bed, he's on medication, he might clearly remember one face, not another, and it's possible the jury could take it that way.
That's right. And I think that's what the prosecutor needs to argue on summations, that, look, we don't get to pick our witnesses out of central casting, right? But here's a witness. He testified. He was a victim. He was shot. His life will never be the same. The trauma of going through that, being in the coma, you know, and even the idea of being shot, it's just something he'll never recover from. And certainly, while sitting in that hospital bed, it's believable that he could have seen all three do the shooting. So that is believable. Obviously, the defense is going to argue that his testimony is incredible, that you can't start changing your testimony midstream and all of a sudden we're at the trial stage, and it's very convenient for the prosecution to now implicate all three when the rest of their case fell apart.
Yeah, and that's exactly where the defense seems to be going with this. And it seemed to be their strategy from the beginning, because if you go through the police reports, very few of the witnesses implicated anyone other than Laquan Barrow. But we know from some of the police reports there were 3 guns involved, and that the majority of the bullets were fired from one gun. Well, logically, we could conclude that was Laquan Barrow's gun. There were 4 bullets fired from a second gun and 4 from a third. That adds up to the 21 bullets. So if you got 3 guns, okay, 3 defendants, the jury might look at this and say, hey, look, you know, we're buying this. We get that these guys have credibility issues. We get that there's a code of silence. We get that they're afraid of repercussions. If they walk out of that courtroom, is a friend or an associate of the defendant's going to try to kill him for testifying? And the jury might look through this and say, hey, look, this is just a bunch of bad characters, but we believe that these 3 were involved in this.
Right. And it's, look, and the defense has got to argue on summation, it's proof beyond a reasonable doubt. So even if you think he did it, or you speculate that he did it, or you hypothesize that he did it, you must vote not guilty, because the state has this very high burden, the highest burden in our land. And I think the defense really needs to bring that point home, especially for the other, not, you know, for Laquan, you know, Laquan, they have a much stronger case against Laquan. But for the other 2 defendants, King and Smith, you know, certainly the defense has to bring those points home, and they have to get the jury thinking in that way in the laboratory, which is called a courtroom, where they have to apply this very high standard. And they should have been doing that all along during voir dire and during opening statements as well.
It's all about burden of proof. Now let's talk a little bit about courtroom behavior here, because you've got the most seriously wounded of the 5 victims up on the stand, and one of the defendants is sitting over there snickering, drawing pictures on file folders, you know, talking to what it looked like his co-defendant, not to his lawyer. The jury looks at that and says, wait a minute, can you guys at least show some degree of decorum in a courtroom where someone who may have almost lost his life is up there describing what he thinks you did to him?
You can't make this stuff up. I've had clients falling asleep on me. You know, they're sitting at the defense table, their entire lives are at stake, and they're falling asleep. I'm like, you know, you're falling asleep? This is your case. This is your trial. So, look, there's only so much the attorney can do in explaining to the client, the defendant, that you have to have respect for the proceedings. You have to show the jury it's the optics of the courtroom. The jury needs to see you showing respect for these proceedings. If you're laughing and you're joking around and you're doodling and you're doing all kinds of nonsense and you're laughing at you're not taking the proceedings seriously, and that always works against you.
Yeah, I'm not sure how the jury would be interpreting that, other than to say this just doesn't look good. This looks like you're goofing around. Yep. You're not respecting what's going on, and you know, the body language tells everything.
It's interesting. I had a client where, you know, when you're nervous, many times people, they smile, they out of nervousness. But it looked like this client was not respecting the proceedings, but it was really a nervous condition. So you have to be cognizant of all of that stuff. The body language, you got to be looking at your client at all times to making sure that they are showing respect. You want them to have a pad in front of them. You want them to be taking notes. I don't care what they write on the pad, but as long as it appears that they're involved in the proceedings, they're respectful, and they're taking notes, that's the kind of image that you want. You also, obviously, you want them dressed properly for court, and it's all the image. I mean, this guy, he had a lot of tattoos all over his arms, which is not dispositive of anything.
You can't remove them at this point.
A lot of people have tattoos, but you should try to cover them up because a lot of those tattoos are affiliated with gangs.
So one more thing. One of the critical things in court is looking at the witness's demeanor. And this is a trial where we've been asked not to show a number of the witnesses. So we don't know what the witness looks like on the stand. We can just hear the tone of voice. And some of the witnesses sound like they may still be struggling with injuries that they've had, but we don't get to see the body language.
Right.
We don't get to see whether or not the witness is coming across in a believable way. We can just judge it by the sound. So we're missing a big chunk of the nonverbal communication. Most communication, as I used to tell my students when I taught this course in college, is nonverbal. That's how we pick up on cues, and that's why we've got the confrontation clause in the Constitution. That's why you have to put the witness on the stand, why the state can't lead the witness all over the place,
Right.
or at least isn't supposed to.
That's right.
It's supposed to be the witness's word and the witness's demeanor to be judged by the jury. We're missing a part of that. But based on what we can hear, does the witness that you just heard seem credible?
It's a tough one. There are certain parts about his testimony, and weighing his testimony against the history of his testimony too. There's certainly many pieces of his testimony which are, from a defense standpoint, completely incredible, and they're picking apart those inconsistencies. The fact that he does remember 3 defendants when originally he only remembered 1 defendant. I think that's something that could be devastating to the prosecution's case. That in and of itself. However, the witness, what's he getting out of this testimony? So we had one witness already that refused at all to testify. We had a witness that stated that the police, compelled his statements against his will.
He said that the only reason he felt threatened is because they were asking him questions. Well, merely asking questions is not threatening.
I think he was on medication also, he said. And, so look, we have this witness. He doesn't have anything to gain from testifying. In fact, I'm sure this is the last thing in the world he wants to be doing right now is testifying against these 3 people. I'm sure he just wants to get out of it and go home and be done with this. So he really has nothing to gain by testifying on the stand right now. And some of his testimony, in my view, did seem real. It was very powerful, especially the part where he said, "I would never forget that face," and
the face of a person who tried to kill me. That was the wow moment. The prosecutor was probably just like slam dunk right there.
Look, they tried to kill him. So, he has to be looked at as a victim in this case, notwithstanding his criminal history and everything else, and the fact that he was part of this whole universe, of what was going on, the beef that was going on between everybody. But at the end of the day, it's on closing statements. You got to bring that home. Prosecutors got to look at that jury and say, look, you may not like him, you may not like the fact that he's got 6 felonies, but he had nothing to gain by coming in here. And we don't pick our, when you're the gang shooting outside of a club, we don't pick our witnesses from central casting. And there's nothing about his testimony that you shouldn't believe. He had nothing to gain by coming here. He pointed out the 3 defendants. We know that there's 3 guns. We have other evidence that puts these 3 at the scene. So the prosecution has to put that piece of testimony in conjunction with all the other evidence that they have in the case, the ballistics evidence and all the other evidence that they have, and just tell them we're not relying on his testimony alone. But, we wanted you to take that in collaboration with all the evidence that we gave you. That's one piece of the puzzle.
Yeah, it's almost like, if you've got plots on a map, the state is trying to say, hey, look, you've got to draw a clean line through it somewhere. This witness didn't see everything, but at least saw one of them. This witness didn't remember everything right out of surgery, but remembers it better today. And that somewhere in here, we can find a clean trajectory, if you will, through what actually happened at this scene.
That's right.
So, while we're waiting for this mid-afternoon break to wrap up, I want to go back and review some of the previous testimony. This is Dee Dee Webster, one of the other witnesses who was on the stand.